Delphi update. The defense attorneys strike back. The equivalent of a legal bomb was just filed by one of Richard Allen's former attorneys, Brad Rousy. Here's a quick update. On October 19, 2023, the trial judge called for a televised hearing in Allen County to address certain matters that had developed in the case. Things were pretty tight-lipped about what was going on, but it was a pretty solid bet. The trial judge was not happy with the 136-page memo filed by the defense team requesting a Franks hearing, and the trial judge was, understandably, not happy with the leak of crime scene photos from the offices of one of the attorneys. So this October 19th date comes, and to everyone's surprise, there is no hearing. About 30 or so minutes after the hearing was to start, the trial judge comes out and announces counsel for Richard Allen had withdrawn, and this was an unexpected development. Other than speculation, no one had any idea what had happened until now, or at least we have at least one side of what happened. Bradley Rousy, Richard Allen's appointed public defender, who, while in chambers, had orally withdrawn from the case, has filed numerous documents today. There are two big ones: the notice of intent to continue representation of Richard Allen and a motion to disqualify the trial judge. Let's go through these real quick. The big boy filing is a verified notice of continuing representation. This thing packs a punch with some behind the scenes goodies. In this verified motion to continue representation, Attorney Rousy states that the trial judge sent both appointed attorneys an email on October 12th to cease work on Richard Allen's case until the October 19th hearing. That allegation alone is powerful. A judge telling appointed counsel to stop work is something I have never seen or experienced in my nearly 20 years practicing criminal defense in Indiana. Attorney Rousy then sent an email asking for clarification of what was going to happen on the October 19th hearing. And I get that. Rousy and Baldwin are told to stop working on the case. There are probably tons of thoughts going through their heads. Are we going to get yelled at? Are we going to get a dressing down? How much trouble are we in? As human beings, we want to know what we're getting into. And in fact, this is going to be a televised hearing. So in response to this email from Attorney Rousy, the trial judge tells the attorneys to get to the hearing at 12:30 to have an in-chambers meeting. Rousy alleges in his motion that when Baldwin and himself arrived at the 12:30 p.m. meeting in the judge's chambers, the judge gives them two choices: withdraw before the hearing, or we can do the hearing and the trial judge will read a prepared statement to the full gallery and to the TV media, telling everyone that both Rousy and Baldwin have been grossly incompetent in representing Richard Allen, and the trial judge will then publicly remove them from the case. So basically, withdraw before the hearing, or you're going to be called grossly incompetent at a nationally televised hearing, and then you will be removed from the case. Attorney Rousy then states that he did orally withdraw, but only did so because he was forced, coerced, and driven by circumstances created by the trial court. Quit or be shamed in public before being fired. Rousy then lists various reasons why he should be allowed to continue representing Richard Allen, including Richard Allen wants him on the case. Rousy wants to be on the case, that any further delay would hurt Richard Allen's case, and that Rousy has done nothing to disqualify himself from this case. Attorney Rousy ends his motion notifying the court that he intends to carry on the representation of Richard Allen. A few important notes. This notice was done as a verified motion. In Indiana, when an attorney signs a pleading, such as the one filed by Rousy, it means the attorney has reviewed it and there is grounds to support the motion. Now, verified motions are a bit different. When a motion is verified, it's signed under the penalty of perjury and the attorney is signaling that he has personal knowledge of the facts. That's in Indiana Rules of Trial Procedure 11C. So basically, by signing this as verified, Rousy is attesting to the truth of what is inside this motion. I won't lie, I think this is awesome. This is some very rare behind-the-scenes stuff that I have never actually witnessed. I know people have different opinions about defense attorneys, but I think these guys have done a stellar job representing their client. Because of the defense attorneys, we know there are at least some prison guards that are pagan heathens wearing "In Odin We Trust" patches on their uniforms. We know that Odinism was something investigated by the original investigators as having a legitimate connection to this case. We also know that the investigators have lied, or at the very minimum have not been forthcoming with the defense attorneys about the identity of the Purdue professor consulted about the connection between the crime scene and Norse paganism. And we know that the timeline of the original probable cause affidavit is, for the lack of a better word, lacking and incomplete. Nothing I've seen indicates that Richard Allen is innocent, but I clearly have many more questions about the evidence and the investigation. And those questions are a direct result of the efforts of the defense attorneys. Now, does any of this matter? It doesn't look like it, because a few minutes after the pleadings became available online, the court posted a backdated order removing both Rousy and Baldwin as Richard Allen's attorneys. In fact, the Indiana's online docket system, both attorneys have been removed as attorneys for Richard Allen. Now, the second legal bomb that was filed was a motion to disqualify the trial judge. Attorney Rousy filed this motion to disqualify the trial judge, listing various things, including the fact that some defense filings have been hidden or removed, and the judge ordered the appointed counsel on 10/12 to cease work on the case. But the juicy stuff is about the quit or be fired proposition Attorney Rousy claims the trial judge put them in. Again, Rousy claims under penalty of perjury, the judge presented them with the choice of a public shaming and being kicked off the case, or they could voluntarily withdraw. Rousy then lists the grievances he believes the judge had against both himself and Attorney Baldwin. Number one, on November 22nd of last year, there was a press release that was done prior to the gag order. How could the criminal defense team not do a press release when you had the investigators on TV saying Richard Allen did it and they're 100% sure they got their man? The defense team had to respond to that. The second issue, 2 motions were filed addressing the health and safety of Richard Allen and the desire of Richard Allen to be transported away from Odinist worshiping guards. Attorneys are supposed to look out for their clients. If they believe he was in danger, they had an absolute duty to act. The third reason, there was some sort of email issue where Rousy was sent an email by Baldwin that was inadvertently sent to some other person with a similar name to Rousy. Obviously, that's embarrassing, but Rousy asserts that nothing too sensitive was actually disclosed in this email. The fourth reason was the 136-page Franks hearing memo that was not filed under seal. Well, there was no order to file things under seal. And in fact, filings are supposed to be public. And this was the same legal filing that brought to light Odinism, problems with the probable cause affidavit. For many people, this is an eye-opening into the investigation that's going on in this case. The fifth reason was that a tort claim notice was filed in this case by the criminal defense attorneys. Tort claim notice is basically a notice to the government that a person may or may not sue them. It's basically like a mini statute of limitations that a person must comply with if they want to later on sue the government. This is the first I've heard of this. I don't know why a judge would get mad about this, except that it's not normally done by criminal defense attorneys, but rather a civil attorney. But it's not unheard of for a criminal attorney to help preserve someone's rights, especially given the fact that this guy's in jail. And last but not least, the fact that Baldwin hired an attorney to speak for him in attempting to explain how the evidence, particularly crime scene photos, were stolen from his office. Now, I don't blame Baldwin for bringing an attorney to the case to talk about this. Back before the hearing, I thought it was a bit overkill, but considering the information in the memorandum and the stop work email, I don't blame Baldwin one bit for bringing an attorney on this matter. Now, Rousy ends his disqualification motion with the judge is biased and should disqualify herself based on various violations of rules governing judges. Now, this motion to disqualify is not something I've seen too often. In fact, I've never seen anything quite like it. Could you imagine if the trial judge allows Rousy to stay on the case and then does not disqualify herself? How awkward would that be? I would not want to be in the trial. I would not want to be in Rousy's shoes in that situation. Between the motion to continue representing Richard Allen and the motion to disqualify the judge, Attorney Rousy has really put himself out there for Richard Allen. And I have no choice but to be proud of him as a fellow defense attorney. Filing this stuff takes, for the lack of better words, tremendous courage and the willingness to put one's money where their mouth is. These documents are obviously one side of the story, and I've never seen a pancake so thin that did not have two sides. I am on absolute edge to see how the state responds to this or how the court responds. It's important to remember that Richard Allen is innocent until he is proven guilty in a court of law.